me see if I can record on my end.
I just started recording, so we should be recording now.
Excellent. Thank you so much.
You're welcome.
Alrighty, everyone. Well, this town hall will cover the updates to DACA as well as student visas, and the immigration attorneys from Curry, York and Associates Immigration Law will also be talking about immigration reform efforts. My name is Estefany Peña Figueroa, and my pronouns are she, her, ella. I'm one of the student specialists with the Immigrant Services Program at MSU Denver. Again, thank you everyone who helped with the planning of this town hall, as well as all of you for being here today. For this agenda, we will review, like I said, updates or the recent changes to DACA, as well as updates to student or F-1 visas, immigration reform efforts. And at the end, we will have a section where you can share your reactions on the chat and also ask your questions on the Q&A function. And at the very end, if you are still with us, I will be going over some on and off campus resources for the Dreamer and immigrant community, not only at the Oradia campus, but also outside in the community. Now, I really quickly want to go over how to navigate your toolbar on. So really quickly here, you can mute or unmute. Since it is a webinar, the attendees will not be heard, or there's not a section for you to mute or unmute. But we do have here this Q&A section where you can ask your questions. And again, we're going to go over those in a specific section. Also, please click on the chat button to drop a message or tell us something, share comments, suggestions, feedback if you want to. And again, this is recorded, so just be mindful about privacy if you have any concerns. If you want to watch the recording of today's event, or if you want to share this information with somebody else, a family member or a friend, they will be posted on MSU Denver Immigrant Services website under recording of past events and workshops. Okay, and so who is presenting here with us? We are having Lisa Jork, who is a managing partner with Curry, York and Associates Immigration Law, and Adriana Romero, who is an immigration attorney. You can find them here at www.cwavisilaw.com. And we can also share with you this information in the chat box. So without further ado, I'm going to hand it over to both Adriana and Lisa. And again, if you have any questions, please let us know.
Thank you so much. Can you hear me? Okay, good. So my name is Lisa York. I think we're just going to take a couple minutes to introduce ourselves before and then we'll start the presentation. I am an immigration attorney. My practice generally focuses on U.S. business immigration. So I help employers obtain work visas for their employees and then sponsor them for permanent residence. We do a lot of family immigration work. And are very excited about hopefully some upcoming changes in the immigration law that will help improve the status of a lot of folks in the upcoming near future. I have been practicing immigration law for almost 20 years now. I graduated from law school in 2002 and hit the ground running. I knew from the very beginning that I wanted to be an immigration lawyer, and it really is just an honor to be here with you all today. So I'm going to turn over to Adriana so she can introduce herself.
Thank you, Lisa. So as Stephanie mentioned, my name is Adriana Romero Quesada. Can you all hear me okay? Can't tell. Okay. And yes, I work with Lisa at Curry, York and Associates. I graduated from DU Law And while I was a student at DU, I worked in the internationalization office. So I was a resource for F-1, J-1 students, as well as our DACA recipients. Right out of law school, while I was in law school, I started working with Lisa, and I'd been working in immigration in different areas of immigration law since then. I have some experience in removal defense, asylum. I've done a lot of family-based immigration. So I work with those petitions where family members petition for their spouses, children, parents. And now more recently, I've gotten into employment-based immigration. Immigration law and concerns are very, very important to me, as I'm a proud daughter of Mexican immigrants. So it is something that I've dealt with my entire life and I'm very passionate about. So I'm, like Lisa, I'm very excited to be a part of this.
All right, so I think we can start with kind of an overview of what's going on with DACA.
Okay, great. So just starting with DACA, we're gonna talk about first what DACA is. It is a temporary protection program from deportation for individuals who entered the country before a certain time and they are here undocumented, and they were brought in right when they were still children. This is not a pathway to citizenship as the program stands right now. It is just a temporary program that began in 2012 under the Obama administration. And then in 2017, Trump administration announced that they were going to begin phasing out the program, right? That they were going to try to get rid of essentially what the DACA was doing. So they started doing that by not accepting initial applications and not accepting applications for advanced parole. We'll talk about what that is. And then as soon as the Biden administration took over, they announced that they were reinstating the DACA program and that they were reinstating it to its original, what it originally looked like. So the basic requirements that were established in 2012 are, number one, that you were physically present in the United States in June of 2012. And then you also have to be physically present in the US when you're submitting your application. So this is not an application that you can submit it while you are abroad. There's also an age requirement. You have to have been born on or after June 16th, 1981 to benefit from this program. And you have to have lived in the United States continuously since 2007, meaning that you have to establish a residence here, and some absences from the United States will be excused for humanitarian reasons, but essentially you have to have been here the entire time since 2007 to the point where you are applying. You have to also have entered the United States before age 16. And then you have to be enrolled or have graduated from high school, a GED program, or currently enrolled in a vocational program, or maybe even honorably discharged from the armed forces. So you don't have to be in school when you're applying for DACA, but you have to have graduated from one of those programs. If you have a criminal conviction, you may be ineligible for DACA. We'll talk about what those mean later in the presentation. And finally, the program is for people who don't currently have lawful status and didn't have lawful status in June 2012 and who do not pose a threat to national security. Okay. So applying for DACA, one of the questions that we get a lot are what are the evidentiary requirements, right? It is a concern for a lot of potential DACA recipients that they don't have a passport. And that's not required. So in the instructions on the USCIS website, you'll see that they have a list of different types of IDs that they will accept for the purpose of applying for DACA. Those include a student issued ID, a birth certificate accompanied by a picture ID. There are a few options. So passports, not having a passport does not make you ineligible. Another requirement for as far as evidence that you have to submit with that initial application is proof that you meet the physical presence requirement, right? That we talked about, that you have been living in the United States continuously since 2007. Now, the types of evidence that you can submit there's not a limit to the type of evidence that you can submit. So the USCIS, again, in their instructions lists examples of evidence, but if you can think of something else, or you can find documents that show where you were living during that period, you can definitely use them. Rent records, bills, religious certificates, pictures, check-ins on Facebook, anything like that. As far as, oops, and I'm sorry, that's supposed to say criminal record. So the last bullet point, a criminal record, we talked about things that may make you ineligible to benefit from the DACA program. Number 1 are felonies. Number 2 are what USCIS considers serious misdemeanors. Although they don't necessarily define what that means, we know that it may include misdemeanors that have to do with burglary, domestic violence, sexual abuse, that's unlawful possession of a firearm, or really important in the state of Colorado, drug distribution or trafficking, possession of marijuana. We all know that for those of us who are 21 years or older, marijuana is legal in the state of Colorado. However, federally, it is still a illegal drug or narcotic. And foreign nationals, including DACA recipients, have to abide by federal law. So any state or federal convictions that have to do with marijuana possession can definitely make you ineligible to benefit from this program. The last disqualifier is if you have 3 or more simple or quote unquote non-serious misdemeanors. And those can be any misdemeanors that you received a sentence of 90 days or more. Okay. All right, so advanced parole has been one of the hot topics around DACA, especially now that it has been reinstated. Like I mentioned, when the Trump administration started phasing out DACA, or attempting to phase out the DACA program, they stopped adjudicating applications for advanced parole. They stopped accepting these types of applications. Now we are able to apply again. And basically what advanced parole is, it's permission to travel outside of the United States. So you can apply for advanced parole if you meet the requirements for 3 different categories. If you can establish that you need to travel for a humanitarian reason, educational, or employment. Humanitarian reasons for travel or applying for advanced parole may include, they include very serious situations abroad. So perhaps you needing medical treatment that you can't find anywhere in the United States, and you have found a doctor or facility that would provide that treatment outside of the US. Also having to visit family that are currently experiencing some type of emergency, medical emergency, or even if perhaps you weren't able to say goodbye to a family member and you need to travel to a different country to just sort of take care of their assets. Those may include those are some humanitarian reasons that USCIS would approve advanced parole. As far as educational and employment, these are trips or you needing to travel because your school or employer requires it or really needs you to go. So those types of petitions would be submitted with lots of evidence and supporting documents showing that it is part of your educational program or it is part of your job to travel. Now, very important with advanced parole is that it is not a guarantee that you will be admitted into the United States when you're ready to come back, right? So USCIS can grant you the permission to leave, but when you are at the border, ready to come back in, whether that be a land border or at an airport, Customs and Border Patrol can deny you entry, right? And they can find you inadmissible to the United States. So when applying for advanced parole, it is very important that we take that risk and benefit analysis and that you discuss your options with a legal representative to determine whether it is worth it for you in your case to take that risk, right? Because when you leave, you always have, because you are here and documented, and we leave, we always have run the risk that we can't come back in. And then we'd have to deal with other types of applications then. So this is it's a great opportunity for some people, as it does provide a way to adjust status for some of us, and for some of us, it's the only way, right? Is to leave the country and come back and have that lawful entry before we can apply for adjustment of status or green card. So not an application to take lightly, but if you think that you may qualify for that, I definitely suggest that you go over those options with a legal representative.
All right. So now we are going to switch gears, and we're going to spend a little bit of time talking about kind of what's going on for international students. Folks who are here as F1s or J1s, and proposed changes to the student program. And I'd like to talk a little bit about the impact of COVID and how COVID has really thrown a wrench into international students' ability to get here, to get to school, to stay in status because they're working on, or schools have been shut and they can't go to class and they have to take online classes. And it's just been, as I'm sure everyone on this call knows, a bit of a mess over the last year. But first of all, I just want to talk about a proposed regulation that was proposed under the Trump administration. And I am hoping that by focusing all of my time and energy on this today, it will ensure that this rule never sees the light of day, because I think it's going to, if it did, it's going to create some significant changes for both F1 visa holders and J1 visa holders as well. And so basically, this is a proposed rule. It was proposed on September 25th of 2020. And it was published in the Federal Register. And what it does, among other things, and we'll go through a little bit of what this rule proposes in just a moment, is the elimination of admission for duration of status for F and J visa holders, and also M visa holders as well, or I'm sorry, I visa holders as well. Those are folks who are coming here as journalists, international media and international journalists. Up until this rule was proposed, F and J visa holders were admitted to the United States for what we call duration of status, which means that they were allowed to come to the United States for the time, and they were considered for the time that it took them to complete their program, as long as they were making what we call normal progress towards the completion of the program. And normal progress means being enrolled in the right number of classes, doing all of the things that are required to maintain your status. And as long as you did that, you were allowed to be here and in status until you completed your program. This proposed rule eliminates the duration of status and replaces it with a 2 or 4 year period of admission. And thereby, I think, would create a very different program for students and J visa holders going forward. And kind of just a brief summary of some of these proposals. And I think we're back on the student slide. Sorry. Thank you. So in addition to replacing duration of status for F and J visa holders with a two or four fixed period of admission, which would be based on the program end date. It also creates a 2-year limit of stay for certain F and J visa holders, mainly for citizens of countries, those visa holders who are citizens of countries with an F or J overstay rate of 10% or higher. And the DHS would then publish a list annually in the Federal Register of all the countries that have a 10% or higher overstay rate, and thus citizens from those countries would be only limited to a 2-year stay here in the United States. There are other specific requirements for that 2-year limited period of stay. And I am not going to go into detail on that. I'm just kind of overviewing it at this point in time. Students who are coming as language students would be limited to a 2-year period of time in the aggregate. This new regulation would create a process for F and J visa holders to file extension of stay applications on Form I-539 to allow them to remain in the United States beyond the fixed period of time that they have, the 2 or 4-year period, if they can meet certain requirements. The timely filing of this I-539 extension of stay application would automatically grant an extension of stay while the application is pending with the USCIS and enable F1 students and J1 exchange visitors to continue a full course of study or their J1 programs while the application is pending. The timely filing of the I-539 would result in the automatic extension of work authorization for F1 on-campus employment, off-campus employment based on severe economic hardship, or STEM OPT employment for 180 days. However, if the application was not adjudicated within 180 days, then the student would have to stop working. Notably, J1 visa holders would be eligible for the 180-day automatic work authorization extension, but their spouses would not be eligible for the same work extension. But again, they would have to stop working if their application was not adjudicated within the 180 days. And USCIS would then deny I-5389 applications if the F or J visa holder violated their status. Violations include dropping below a full course load of study without advance permission from your foreign student advisor or DSO, and a pattern of academic suspension or failing classes would be considered to be a reason to deny an extension of status application. Additionally, F1 students applying for post-completion OPT, optional practical training, would need to file both the I-539 application and an I-765 application. That's the application for the OPT work authorization. The timely filing of the I-539 application will automatically extend the stay for 180 days, but students will not be able to start working until they have the employment authorization document in hand. In addition, the F1 grace period would be shortened from 60 days to 30 days. There are a couple of little good things about the proposed rule is that the F1 cap gap, that is where if someone's F1 status or their OPT is ending and they're in the process of applying for an H-1B visa through the lottery and their work authorization is ending and they've been accepted or won the lottery, that enables them to extend their F1 status and their work authorization until October 1st currently, so they can start in the H-1B status if they are approved for H-1B status. This cap gap would be extended from October 1st of each year to April 1st of the following year. And it also creates a J1 cap gap period, which is currently non-existent. that would be published in the Federal Register each year once it is determined that all the H-1B cap visas have been used up for that year. That is kind of a summary of some of the major changes that this rule would present. The good news that I have is that it is currently on hold. This rule was not published in the Federal Register. It did not become a final rule before the Trump administration left office at the end of January. And as of today, there is no indication yet that the Biden administration is going to be moving forward with this proposed rule. It is completely in a state of limbo at this point in time. And quite frankly, we just have no idea whether or not the new administration is going to proceed or move forward with this. So luckily, the good news is it's not something that we have to worry about right now because it's on kind of indefinite freeze until we hear otherwise. But it is definitely something that we all have to keep our eyes and ears and on the lookout for. And I know that universities and colleges and schools across the nation, as well as their immigration council and all of their advocates for international education, as well as international students and exchange students, have put up a huge fight to stop this regulation and this new rule from going into effect because it's going to have such a detrimental effect on international students and international education. But it's just something for us to all just keep our eyes and ears out for going forward. In addition to that, I just want to mention, I had sent kind of a handout earlier today. You can feel free to circulate this to anyone on campus, post it on your website. It is a handout that was created by the American Immigration Lawyers Association, which is the national and international bar association of all immigration attorneys in the nation. But it really kind of goes through and talks through some of the unique issues that students are facing and have faced over the last year. I can't believe it's already a year since the whole COVID thing started. And we're still dealing with it at this point in time, but all the unique situations and circumstances that students are finding themselves in. And kind of summarizes the guidance to date that has been given on how to deal with situations of being able to not work physically at your employer's place of work if you're on OPT or CPT, guidance on how many classes students can take remotely if their colleges or schools are closed and you can't go in person to classes. And as I'm sure everyone on this call today is aware, it has been, a kind of a mixed bag. There's the guidance isn't very clear. It's, ever changing on a day-to-day basis. And it's very hard to kind of stay on top of what the requirements are, what the rules are, what you need to be looking out for and not looking out for. And in addition to kind of just verifying that, yes, it's very complicated and it's kind of changing on an everyday basis. It's just a reminder to rely on your campus resources, your International Student Office and your DSOs are very much staying on top of this. And if there are any students or J scholars on the call, definitely stay in touch with your International Student Office to stay on top of all of these very kind of bizarre and changing circumstances. And then finally, I'm going to end it on a good note. Very recently, at the end of January, there has been a lot of litigation over the last few years about whether or not the STEM OPT program is legal and whether or not the OPT program is legal. And the district court finally ruled at the end of January that both the STEM OPT program and the OPT program are legal. that the regulations creating STEM OPT and the previous regulation creating OPT, that there was no abuse, they are fine. And given that we have had a change in administration, and we know, or we sense, I think we have a pretty good sense that the Biden administration supports international education. It supports the continuation of OPT and STEM OPT. It is likely that at least the administration will move forward and continue with those programs. It remains to be seen whether or not there will be any more litigation around those issues. And the last thing I want to kind of cover in terms of COVID-related situations for international students is that recently, I think it was last week, the Department of State is starting to kind of lessen some of the restrictions, the COVID-related restrictions for international students who are outside the United States and coming to the United States. Specifically, these are the students who are in Europe, the UK or Ireland. The Department of State is basically waiving the requirement that they apply for a national interest exemption to allow them to come to the United States during all these different COVID restrictions. They will automatically be considered for that national interest exemption because, again, this administration realizes the importance of international education. As far as I can tell, we haven't seen any relaxation or change in the requirements for students who are coming from some of the other countries that are banned from the US, well, not banned, but that have the COVID bans, such as Brazil or South Africa. But it seems to be sort of a shift and a change, at least for those students coming from Europe and the UK and Ireland at this point in time. And that is a little bit of good news. However, it does not waive the requirement that any international traveler coming to the United States have tested negative for COVID within 3 days, 72 hours of boarding a plane. I think that's it. All right, Adriana, do you want to talk about the immigration reform? This all just kind of, it's very exciting, but it's also very new. It just came out on Friday.
Yes, thanks, Lisa. Yeah, going along with proposed changes. So on Friday, the U.S. Citizenship Act of 2021, as it's being called, was introduced to the House. And we're expecting that the same will happen in the Senate today or tomorrow. And it's very important to remember that this is just a proposal, right? So those of us who are a little more unfamiliar with how these sort of bills become legislation, it takes a long time, right? And we know that the way that it's being presented and what is being proposed is most likely not going to be what we see today, right? There are going to be some concessions, there's going to be some wheeling and dealing on both sides, and hopefully there will be bipartisan support for the Citizenship Act. But what we know right now is that the Biden administration has proposed some very great ideas and extensive changes to the current immigration system. So some of the things that have been proposed already is number one, providing a pathway to permanent residence for DACA recipients, people who have TPS protections, and agricultural workers. So the way it reads right now is that it would provide an automatic way for people in these categories to apply for permanent residence. And we know that that's been a goal for DACA for a very long time. So hopefully that is one of the things that everybody can agree on, and that we can get status for our DACA recipients and our agricultural workers. I think this is a reflection of COVID times and who's been identified as essential workers. And I think that a lot of agricultural workers, temporary workers here were deemed essential workers, right? And we identified the importance of keeping them here and providing a pathway to permanent residence. Another very interesting part of the Citizenship Act is what the Biden administration is calling lawful prospective immigrants. So right now there isn't necessarily a DAPA or, for some sort of protections for parents of DACA recipients. However, it seems like those parents would qualify or fall under this other proposed status for lawful prospective immigrants. And this is an application to get people protections who were here prior to January 2021, before this was announced, and who are here unlawfully or undocumented, a way to apply for a protection, much like DACA, a protection against deportation and work authorization. And what's been proposed is that that an applicant would hold this status of LPI for 6 years and then could renew. After being on this status and everything goes well, right, no criminal convictions and no other issues, then the applicant would be eligible to apply for permanent residence. So it definitely would provide a way for people who have been here, for decades and not had any other way to move towards permanent residence. This would definitely get them on the right path. Along with permanent residence, it's been proposed that once a person holds lawful permanent resident status for 3 years, they would be eligible to apply for naturalization or citizenship. The way it stands right now is that some people are required to wait 5 years, some 3 years, and the proposed rule would be just to hold everybody to that 3-year mark. Legislation, the proposed Citizenship Act has also proposed a reforming employment-based visa options, and I think Lisa touched on that very well as well as F-1 and J-1, and asylum reform. We know that during the Trump administration, asylum was a big target, and the way that people could apply for asylum, both affirmatively and defensively, was it slowly got harder and harder and harder during the Trump administration. And there were a lot of legislation around the rules that were imposed and how fast they were applied and the negative consequences of it. So this bill proposes to completely reform the asylum application process as it stands now. One of the big changes would specifically address the issues in Central America. We know that with the caravans and with a lot of people coming to the United States, they are fleeing violence, they're fleeing danger in their own countries, and they don't have another way to apply in their home countries and then wait for some sort of status and then somehow get into the United States. So what's been happening is that they're forming large groups or caravans and making their way through Mexico, which has proven to be very dangerous for them, and then coming to the border. And the way it's supposed to work is that you ask the United States for asylum, and you are allowed in or paroled in while they adjudicate your application and take a look at your case. Because of what was happening with the caravans, we know the Trump administration made a program that essentially made people wait outside of the border, and just sort of hang out in Mexico. So at this point, they didn't have status in Mexico or in the US, and they were having to stay in these very dangerous situations. So what the Biden administration has proposed is making it easier for people to apply for asylum or refugee status in their own countries, especially minors or children who are being recruited into these dangerous groups, whether they be cartels, different La Mara, or any sort of dangerous gang or violent group. If they are being actively recruited, they could essentially apply within their own country, seek safety, and then make their way into the United States. So that would help alleviate the stress of the caravans and all of the danger that it has caused. Reform for the visa backlog and country caps has also been proposed. Now, this is something that it is the visa bulletin, right? It's this list of, and it shows when people become eligible, applicants become eligible to apply for adjustment of status or green card or permanent residence, right? They all mean the same thing. And this list is extremely backlogged for various reasons, right? And one of them being that there are caps per country. So essentially the United States has an amount of visas for, visas that they will grant people, each country, right? And how many people from that country can apply for adjustment of status. For certain countries, Mexico, India, China, these lists are not, the amount of visas that are allocated to these countries are not enough. So we know, I personally know from our experience, as far as Mexico, some of these visa backlogs it is up to 20 years, right? Well, so we've seen that where a family member can petition for somebody and they have to wait for 20 years before they become eligible to apply for adjustment of status. So the plan is not only to clear out this backlog and start adjudicating these forms more quickly, but also rework the country caps and rework the way that we're distributing these visas in different categories so that people aren't having to wait that long. Another part of the citizenship has been border security. So I think what was most interesting when we were listening to the Biden administration talk about what they consider as being border security is that it's not necessarily hiring a bunch of people and putting them at the border and arming them and hoping that it makes our border more secure. I think that they're taking a very holistic view of border security, and they are looking into using things like drones and maybe smart technology to help keep everybody at the border safer, right? Not only those working for Homeland Security, those trying to enter, and those that go back and forth, right? We have a lot of people who go back and forth on the border every day. So keeping these locations safer by using better technology, and then also training, right? A lot of people are put into these situations and they're not trained properly, because the idea previously was just to load the borders with personnel and hoping that that would keep everybody safer. So I think that that's one of the other very interesting parts of this proposed bill. And these are just some of the highlights. I do want to finish this slide by just, again, reiterating, this is a proposal, okay? And so in the spirit of keeping our immigrant communities safe from fraud or getting taken advantage of by other people, is just that if you are unsure if something has gone into effect or if there's a new law that may benefit me, definitely talk to, I know that we're going to talk about some resources at the end of the presentation, or an attorney or a community organization that will help sort of let you know what is going on, because with these proposed changes, as always, there are going to be people who try to take advantage of it, right? So if you see these announcements on Facebook saying this may happen, come apply now, I will charge you to do this now. I really like you to first look into the post, see who it is, and then talk to somebody who may have more information. All of this is just being proposed. It will be a while before we see what will actually result of this bill. All right.
Thank you. Just a couple more comments about kind of this proposed rule. Adriana mentioned that we're taking a holistic approach. And I think that is very encouraging. The word that used to be used, and I will say it, although I think it might be politically toxic at this point in time, is comprehensive. Over the last 10, 15 years, efforts to have immigration reform have fallen short and significantly short. And there's been a huge debate about whether or not to try to like piecemeal it and address one little piece of it at a time, i.e. fix asylum first and then work on legal immigration and then work on, the folks, DACA and the folks who don't have status in the US, rather than doing kind of a comprehensive, a holistic approach where we try to address the whole thing at one time. And I would say that I think most immigration attorneys would applaud kind of this holistic approach. Our system is so antiquated. It was the last time it was majorly reformed was in 1965, and it is so out of date that just doing one little piece at a time is not going to be effective. And so, I applaud the Biden administration for taking a holistic, comprehensive approach and trying to tackle it all at once. We will see what happens. And I am an optimistic person. I'm very hopeful that at least some of this, these good proposals will come through, but we will have to wait and see. All right, and so we've sort of already talked about some of these things. A question that we are getting right now from everyone is, we've just come out of 4 years of the Trump administration, and we've seen what's happened to the US immigration system, as Adriana mentioned, especially the asylum system over the last 4 years. What can we expect with the Biden administration coming in? And we now sort of have the Biden administration's kind of vision of how immigration reform will go. And I think that's a good sign of kind of what to look forward to and what to anticipate. But I think it's really important to highlight that under the Trump administration, a lot of changes were made. It is close to 1,000 different policy and regulatory changes that went into effect over the last 4 years. Most of those are changes that we didn't want to see or have been very unhappy about. And it's going to take a lot of time to kind of undo and unwind what has been done in terms of coming up with a feasible, rational immigration policy going forward. So I think the thing that we're advocating for everyone to have is, and unfortunately in our today's world, I think this is the key world, no matter what you're talking about, it's patience. We are all going to have patience. And we're going to have to wait, because it's going to take time to kind of see how all of this unfolds and see what is actually possible. We've covered kind of DACA. We've talked about, changes to the F and J duration of status. Hopefully that will never see the light of day. Other issues that are kind of on the horizon is, will the Immigration Service change the definition of specialty occupation for H-1Bs? It looks like that proposed regulation has died or is dying on the vine. We are still grappling with the US DOL wage data rule, which it looks like at this point in time, it's set to go into effect this summer, July 1st, but we are anticipating massive litigation around all of that. And we also know that the Immigration Service, this is also a holdover from the Trump administration, is proposing to change the way we do the H-1B lottery system every year. And they are proposing a wage-based system. Right now, that system is supposed to go into place at the end of this year. But again, it remains to be seen whether or not this administration will support that. Will it take the rule away? Will there be lots of litigation like there was when it was first announced that kind of knocked it back? There's still a lot of moving parts. And we'll have to, again, just kind of wait and see and have patience to see how it all plays out. One of the things I am actually very excited about and very hopeful about is better adjudications from USCIS, less ridiculous, nonsensical requests for evidence, more communication with the public. And one of the things that I think that was really dismantled under the Trump administration was the Immigration Services, USCIS's engagement with the public, and our ability to kind of talk to USCIS about improving customer service and improving processing times and adjudications, and all of that stuff. Sorry about that. My vehicle warranty is expiring, and they keep calling me about that. So apologize for that. Public charge rule. We just got word this morning that the Supreme Court has agreed to hear the case. And so we were hoping this public charge rule, which I think is completely unnecessary and puts a huge burden on folks who are applying for permanent residence in the United States. We were hoping that this one would kind of fade away and die, and there's been a lot of litigation over this, but now we know it's going to be going to the Supreme Court. So again, eyes and ears, we'll have to keep our eyes on this one and see what happens. And then obviously with COVID, there are actually new border restrictions going into place with the emergence of these new strains that we are very scared about, and we don't understand how they're transmitted and the threat that they pose to the American public. The Biden administration has actually imposed additional travel bans on folks from like South Africa and has extended current travel bans. So again, we're going to have to kind of wait and see how this all plays out. Hopefully, as the vaccination level increases and things with COVID get better in the next few months, most, if not all of these travel bans or restrictions will be lifted. And then, the last news, which, we were very happy to hear, the Biden administration has repealed what we call the Muslim travel ban, and allows people from basically Muslim countries to come to the United States where they were restricted before.
Thank you for that very important information. I do see that there are a few questions on the Q&A function. So I'm going to allow Mayra to ask those questions. And then if you have any other questions, make sure you do share them on the Q&A function. Mayra, are you okay with moderating the Q&A? Okay.
Sorry, I'm here. Can you hear me okay?
Yes, I can hear you.
Okay. The first question is there a pathway to permanent residency for international students?
Yes, it's Lisa. Let me kind of address that. Kind of the general route to permanent residence for F-1 students is to graduate, complete your program, apply for and obtain optional practical training that gives you, the opportunity to work in the United States for 12 months. If you are in a STEM field, and your employer is enrolled in E-Verify and willing to sponsor you, you can extend your optional practical training for another 24 months. During that period of time, that is where F-1 students are kind of establishing a relationship with an employer who then hopefully is willing to sponsor them generally for an H-1B visa, which is a professional work visa, which requires at least the minimum of a bachelor's degree in a specific field, and the employer has to pay, agree to pay a minimum salary for the position among other requirements. And then the traditional route is to apply through permanent residence through one of the many different options. The general route would be through the labor certification process, where you're proving to the US Department of Labor and USCIS that you're not stealing a job away from a qualified, willing, or able US worker. But there are other routes that may be available to folks who are doing special research that's in the national interest. If you're working at a university or conducting research, you might be eligible for the outstanding researcher or professor category. And then those who really kind of rise to the very top of their fields, they might be eligible for something that we call extraordinary ability, where if you can show that, you know, the work that you do is very important, and also you have risen to the very top of your field, you can apply for permanent residence. So that is just kind of very general, kind of an overview of the general route to permanent residence. But every person in every case and every situation is unique and different. So if you are an international student and you're wondering about, like, well, what's my pathway forward? That is a really good thing to discuss with an immigration attorney, to just kind of get an idea of what options might be available to you given your personal circumstances.
Great, thank you. We do have another question. Is it possible to renew a F-1 visa without going back to my country, considering that the American consulate is closed in my country because of COVID?
Okay, so this is a really good question. And I think it's important to understand that there's a difference between an F-1 visa and your F-1 status. So the F-1 visa is the stamp that you get in your passport when you initially applied to come to the United States. You were outside the US, you had your I-20 and all your documents, you went to the US consular office, you applied for the F-1 visa, and they put the stamp in your passport. The F-1 stamp in your passport, the only thing it allows you to do is come to the border and ask to come into the United States. It does not govern your F-1 status while you're here in the US. Once you were admitted to the US in F-1 status, you were issued an I-94 document based on your I-20, and that you were admitted D/S, that's duration of status. That is what we were talking about earlier in terms of the proposed changes to change the way that they count that time and the amount of time that you're allowed to be here in the United States. If you are here in the United States and your visa stamp has expired, nothing to worry about, because your F-1 status is governed by your I-94 card. It continues until you complete your program. And if you're changing or transferring to a different program, that is something that your international student advisor and your international student office can help you with. Adriana, do you have anything to add?
Oh, sorry, no, I was muted. No, Lisa, I don't have anything to add other than, yes, important to know the difference between in and out, and then also to keep track of our COVID restrictions, right? Although students a lot of times are exempt to these travel restrictions, as new variants of the disease are coming and we're learning more about COVID. I think that, like Lisa mentioned earlier, that's going to change on the daily.
Yeah.
And then, you know, and I'm sure that you can discuss this option with Aubrey, is just renewing, the possibility of renewing, if you do need to renew your visa for any reason, you do need to go out and come back in. There is the option of renewing in a different country, right? Not necessarily your home country. So I'm sure that Aubrey can discuss that in further detail.
Yeah.
Perspective.
And I think just in general, with everything that's going on with COVID right now, our office's general kind of rule of thumb is that we are advising against international travel, if at all possible. And that is because if you leave the United States, there's really no guarantee that you're going to be able to come back. And if you get stuck outside the US, we have no idea how long you might be stuck and not be able to come back in. So if the rule of thumb is to avoid international travel at this point in time until further notice, if at all possible.
Right, and somebody asked whether they need that stamp on their passport to travel outside. Yes, right, well, at least explain, you need that stamp to enter. You need a valid visa to get back into the United States through a port of entry. So in that sense, you do need to renew. If you happen to leave the country and need to come back in, then you do need to renew that visa, whether your I-20 is still valid or not. Mm-hmm.
Thank you. There is a question that I accidentally dismissed, but I'm not sure if it has been answered. Can you go over the proposed changes to DS?
So yeah, we did do that. We spent a lot of time discussing that earlier. So if you missed that section, I would suggest reviewing the recording.
Perfect. And I will post the link to the recording video. I do have a few questions here for you. And so one of them is, who can help me complete my DACA application or give advice about my eligibility?
That's a great question. Adriana, I'll let
Yeah,
you take that one.
Sure, yeah. When it comes to determining whether you are eligible for DACA status or not, there are really only two types of people that can help you make that determination, right? One being an immigration attorney licensed to practice law. And then there are also approved sort of legal representatives at USC, they sign up with USCIS and they have special permission to help you, one, sort of determine your eligibility and also complete these forms, right? So if you're putting these packets together and assembling them and completing the forms during some of these community workshops, with your university or anybody who's allowed to give you that sort of advice, it is completely okay. Also, of course, going to your own attorney is always an option. What we do not recommend is going to people who say, I know how to fill out the form, I'll help you. Because not only is it not technically, it's not legal, right? But it also may not be in your best interest. Like we've mentioned a lot today, these regulations are changing daily, right? The Trump administration made over 1,000 changes to immigration law, and it was very hard to keep up with them. So you really want to go with somebody who is qualified and allowed to make these sort of determinations so that you get the best advice possible. You know, going to a tax preparer is not an option, or any sort of other person, I guess, or business that is advertising the ability to help you with these petitions.
Great, thank you. And students who are thinking about applying to DACA or possibly for the first time or possibly renewing their DACA, some of them have wondered if their information is going to be shared with ICE.
Right, very, very important question. And I know that this is a concern for parents of DACA applicants as well. The general answer is no, it will not be shared with ICE, right? So USCIS first of all, let's talk about what information you include in your DACA application. The information contained in that application is only about the applicant, right? So information about their parents is not included. So whether your parents have status or not, does not matter. That doesn't go on the application, right? And there are ways to redact the evidence and sort of assemble this packet to make sure that those addresses, those names, those dates are kept private. Now, when that information makes it to USCIS, ICE is not supposed to have access to that information. There are some exceptions though. If for any reason ICE makes the determination that you are a threat to national security, then with that determination, they can pretty much open any door, right? They can access all of that information that's been stored with USCIS or a lot of other government entities for that matter. So yes, careful about what information we're including, but generally it is safe to put your information and trust that it's not going to go to ICE.
Perfect. Since we're talking about DACA, another question is DACA a temporary program or a pathway to citizenship?
Right, and so we touched a little bit about that in the beginning. Like I mentioned, right now, unfortunately, it's just temporary. It's just a presidential proclamation. But hopefully, as the U.S. Citizenship Act makes its way makes its way through the legislative bodies, it will become a path to residency and eventually citizenship. As of now, it is not.
Perfect. And there are a few other questions around DACA. One of them is, what if I was issued a DACA EAD for only 1 year?
Yeah. So part of the phase out program that the Trump administration started, along with not accepting new applications and not accepting applications for advanced parole, is that they decided that instead of issuing work authorization and protection against deportation for 2 years, they were only going to do it for 1 year. Now, after legislation, a few court cases and rules going back and forward, it was determined that USCIS was not allowed to do that, right? They had to have granted it if they approved a petition for 2 years. So if you were issued an EAD document, a work authorization card that was only valid for 1 year, it has automatically been extended to 2 years, right? USCIS has made that announcement, and what they were supposed to do or going to do was send out notices to everybody, a new approval notice, right? Or some sort of document that you could give to your employer to show that you actually have status for, work authorization for those 2 years. So if for some reason you got one of those 1 year ones, don't worry, don't apply to renew now, you have the 2 years.
Sounds great. Thank you so much. And there is another question. What type of advice do you have for our DACA and undocumented students and families and international students on campus?
Sorry, Stephanie, can the question one more time? What sort of advice regarding?
It just says, what advice, maybe if you or Lisa could say any type of advice that you have for DACA and undocumented students and international students right now during this administration.
Well, I guess I would just say that, we're kind of in a period of a lot of change. Things are changing daily. And so I think the key is trying to keep on top of kind of what the situation is, even though it seems to be a moving target. And so I think the biggest key is just keeping informed. And then, if you need to talk to, if you're confused or something's not making sense or you have any concerns, definitely that is, the time to talk to an immigration attorney about those concerns and about what's going on, to make sure that even though it is very uncertain in a lot of cases and situations, that you are kind of on top of the latest information and able to make appropriate decisions going forward.
Excellent, thank you. Well, those are the questions that we had. If you are an attendee right now and you want to ask any more questions, please feel free to share them on the Q&A function. Or if you want to share something with us, just drop it in the chat. But with that, anybody else have anything else to share with the attendees today? Alrighty, I'm going to start sharing my screen again. I do want to go over some of the resources that are available right now. So let me share that with me. So I want to start off by sharing some of the resources that are available not only on campus, but also out of campus. And so one of those is the Dreamer Emergency Fund. Just really briefly, this is available for DACA and undocumented students. They are eligible to apply for it once per semester, and they can obtain up to $1,000. If a student is an international student, also a permanent resident, US citizen, there is also the MSU Denver Student Retention, the Student Emergency Retention Fund that they can apply to. There's also many scholarships available. One of those include the Helen Grace Fenn House, as well as the Dream.US, the Latin American Educational Fund, scholarship, DSF. There's many private, national and institutional scholarships available. You have access to legal services here on campus by, providing this town halls, as well as immigration attorneys coming to campus. Well, right now it's virtual and they're happening every Tuesday, so every 2 weeks. And they started on February 2nd. Also on Thursday, this Thursday, February 25th, we will have a DACA workshop where students will hear from CIRC, or the Colorado Immigrant Rights Coalition, about applying to DACA for the first time, as well as there will be a few immigration attorneys who will be meeting with students one-on-one on private and confidential virtual breakout rooms. So if that's something you're interested in, I will share the flyer with you shortly. My goodness, that's a lot of notifications. But we also have on campus virtual counseling centers. So if you are a student at MSU Denver, CU, or CCD, you are able to obtain free counseling sessions at your institutions. And also, if you go to another institution or another university, reach out and also learn about the counseling resources that they have. Your mental health is very important. So it's important that you do keep a lookout for that. There's also immigrant services program on campus and others such as SKIDA and the CMEI, first generation initiatives, that are always willing to help and support in any way possible. Moving on, these are also national resources as well as important local resources on campus. Starting off with Immigrants Rising, we always tell students that if they're applying to DACA for the first time, or if they are renewing their DACA, they do go to this link here, as they do provide really good step-by-step when going through this process. Also visit the National Immigration Law Center and the ACLU's All Are Welcome National Database of Resources if you're wanting to learn more about what's available nationwide. Also, more locally, the Rocky Mountain Immigrant Advocacy Network is a really great website to follow. If you see any type of ICE activity, please call the Colorado Rapid Response Network and they will respond immediately to any calls that community members may have. And again, the Colorado Immigrant Rights Coalition, as I mentioned, they will be on campus this Thursday. And again, this is going to be a virtual event as well. But that's what we have. If you have any other questions or anything else, please feel free to reach out with questions. We have Lisa and Adriana who are willing to answer any of those questions that you may have. You may find their contact information there. I also am more than happy to meet with you and answer any questions that you may have. You can reach out to me on this email or reach out to Gregor Meter, who is the program director. He couldn't be here today. But also Aubrey, if you want to share your contact information, she's also always willing to share any type of questions answer any type of questions that you may have. But yeah, thank you so much, Adriana and Lisa, for being here. And thank you, Melissa, Aubrey, and Maida for helping out on the planning of this event.
Thank you so much for having us. It's something that, we're very excited. We're very hopeful that some of these proposed changes will go through and the bad ones will just go away. And hopefully we're entering kind of a new era, a new positive era of U.S. immigration. So thank you all for your time today.
Absolutely. Thank you so much. And thank you all for taking the time to be here. I'm gonna stay here a few more minutes, just if there are any more questions. But yeah, you can always find a recording of this, and let me show